Hello, everyone. Welcome back. We're so excited you are here. We have an amazing guest tonight, Dr. Mitchell L. Yell, and one of our dear friends of Special Education Academy. If we haven't met, I'm Karen Mayer Cunningham, Special Education Boss, training everyone that sits at the 504 IEP table to navigate and negotiate successful student outcomes. So, Mitch, welcome back. It's like I
Thank
haven't seen
you.
you in so
Glad to be
long.
back. Glad to
Yes.
be back.
So the real question is, how do we say it? Is it Osseo? Is that the
Osseo. In fact, that's the school district where I graduated from high school.
Oh, so where is that?
It is in Minnesota. It's north of Minneapolis.
Okay. And
So
so
it's a big district. It's actually, I think, now the fifth biggest district in Minnesota. So it's a good sized district.
yeah. So I mean, we have these major cases, right? We have Raleigh, we have Andrew, we have Sturgis, and now we have this. And so people were starting to ask me questions. And I'm like, well, let's go to Dr. Yell. He's quite smart. So can you give us a little history about the background of this case?
Yeah, well, it involved a young girl, Ava, A.J.T by the court. And Ava had a severe and rare form of epilepsy, was educated in Kentucky and I can't remember the school district, but the school district had done a number of accommodations for her. Well, her rare type of epilepsy, she had reoccurring and severe and frequent seizures in the morning. Before noon, she was pretty much, I mean, she was pretty severely disabled anyway, but she could not, she just couldn't attend school. So what they did in Kentucky is they started her school day at noon, stopped it at 4, and because she didn't receive the same amount of instruction as did other students, they did give her homebound instruction from 4 to 6 in the evening by a certified instructor. And her parents moved her to the Osseo School District, and the Osseo School District did an IEP, did accommodations for her. But when the parents asked for evening instruction to equalize her education to the education that non-disabled students would meet, the same amount of hours, 6.5, they refused to do that. And what she did is they went through pretty much every avenue available to them. They filed a state complaint, which came down on their side. They went to they filed under a due process hearing where the ALJ, the Administrative Law Judge of Minnesota, sided with them and ordered, I think it was 800 hours of compensatory education and a number of different accommodations. And that they found the school district had failed to provide FAPE. And uh, but this parents were upset because one of the things that happened is the ALJ used a law or a case out of the Eighth Circuit called Monahan v. Nebraska that said for a school district to have violated 504 or Title II of the ADA, they must have committed uh, bad faith or gross misjudgment. Well, for that and eventually it wound up in court. The court or the school district sued, saying the ALJ used the wrong standard and should not have found him violated FAPE, and the fact that she should not get evening instruction, which the ALJ did say, because you probably heard this before, it would violate the LRE, least restrictive environment, because there would be no possibility of being with peers in the later hours, 4 to 6. Well, the parents filed a complaint, sued in the Eighth Circuit Court of Appeals, which of course is right under the Supreme Court in terms of power. And the Eighth Circuit is the circuit that Minnesota is in. And they found that the school district had violated FAPE. The LRE argument had no merit whatsoever. The IEP had not really been concerned with that, except as a way to counter the advocacy of the parents. And but the Eighth Circuit also said that under the Monahan decision, while the school district had to provide the compensatory education, the parents were not owed any monetary damages. And they then filed a petition for appeal in the U.S. Supreme Court. Now, so there was two separate decisions. They won the FAPE cases everywhere they went. They got the compensatory ed, but they didn't get the monetary damages. So essentially what they asked the Supreme Court is, and the Supreme Court is different, as you know, Karen, because they're not concerned with the whole case. There'll be one or two questions the petitioners, the parents asked, and the parents asked, does a school district need to satisfy bad faith or gross misjudgment, which is a really high standard to meet? And the Supreme Court in a unanimous decision, 9-0, said that no, school districts are not held to a higher standard than anyone. Like, so in an employment case, uh, if a person sued an employment case under 504 or ADA, the employer wouldn't have to have committed bad faith or gross misjudgment. Intent is not that big an issue. So essentially, the Supreme Court said it's a little unfair to make school districts and advocates to having school districts meet this bad faith or gross misjudgment. So essentially, they said no. Bad faith or gross misjudgment is not needed to prove a violation of 504 or Title II of the Americans with Disabilities Act. And that was it. Now, I should say too, it was a unanimous decision, but two of the judges, Kavanaugh and Thomas, said they were pretty much open to the idea that there's no right to education under 504 or ADA. So that's a bit of a problem, but it was very much a decision for parents. So parents can essentially fast track monetary damage claims because they no longer have to use don't have to use bad faith or misjudgment. And in a previous Supreme Court case in 2023 that you alluded to, Perez v. Sturgis, essentially what the Supreme Court said is a parent, if they sued, do not have to exhaust their administrative remedies. If they're suing for monetary damages, they do not have to go through the due process hearing because monetary damages are not allowed under the idea. And if certain damages aren't allowed under the idea, you don't have to use the idea. So, oh, it must be mute.
Sorry. A couple of things you said just made me ding, ding, ding. So, first of all, so was Ava on she was on a 504?
She had an IEP,
Okay.
and of course it's different. IEPs are in special education, but they sued for discrimination under 504 and ADA.
Okay. All right. And so
That she was being treated differently because non-disabled kids were getting 6.5 hours of education. She was getting less than 4 hours of education.
Okay.
There was a disparity and discrimination. And
Okay.
that was their issue. Did we have to prove that the school did discriminate, but in bad faith or gross misjudgment? And that's where the court said no.
Okay. And so, I mean, so this fast track, we don't have to exhaust our administrative remedies. So, ABC parent listening, do they just go down to the local post office and file? I mean, what does that look like?
Well, I should say filing, if you're filing in a court of law, of course, you need an attorney and it's going to be fairly expensive. And they would take care of the filing and do all that.
But
Parents,
what when you're filing for discrimination and
uh,
monetary reimbursement, what avenue is that?
That would be under 504 or Title II of the ADA. Now, parents could go under Section 504 of the Rehabilitation Act of 1973. And of course, the branch of the federal U.S. Department of Education that controls or has control over 504 and ADA is the Office for Civil Rights. Parents
Okay.
could also, on the other hand, file through the Civil Rights Division of the Department of Justice under Title II of the Americans with Disabilities Act.
And did Ava's parents receive, I mean, was it remanded? Is it going to be remanded back and somebody has to pay?
Well, there will be, they essentially said the lower courts were wrong in saying that the school did not meet the Monahan standard of bad faith or gross misjudgment. In it, basically has to be intent in the Eighth Circuit, but it doesn't have to be a degree of bad faith or gross misjudgment in terms of intent. So it's essentially they can sue for monetary damages. That's under Perez without exhausting remedies, and they have a greater chance because they don't have to meet this bad faith or gross misjudgment.
Okay, so that's really what it um clarified, right? Just like
Yeah,
um okay, so just like
essentially.
Andrew F,
School, yeah,
clarified the FAPE question, this
yeah,
clarifies that.
parents don't have to meet this high standard. I mean, it's very hard for courts generally don't say, well, they wouldn't find bad faith or gross misjudgment, unless they found they had committed a serious error and like they ignored something or they ignored bullying, for example,
Right.
didn't do anything about it, that would be gross misjudgment. Or if they knew it was happening and didn't do anything about it, that would be bad faith. But now, and that's a hard standard to prove. That's a high standard to prove. Now parents don't have to prove that degree
Okay.
of bad faith or gross misjudgment. That's all that the Osseo case said.
Okay. Um,
But so what'll happen, Karen, is they will probably sue again
right.
in the lower courts
Okay.
for monetary damages. You
Okay.
probably will never see anything come of that because more than likely the school will say, how do we make this go away?
Yeah.
And they will settle it.
Yeah. Well, I would love that. So something I wanted to ask you, and then we'll open it up to our friends. You know, if I'm seeing it correctly, has OCR been moved over to HHS?
No, not yet. OCR has been really torn asunder. There were 12 offices, now there are five. Um, 40% of the younger folks at OCR have left or been fired or had a opportunity to leave, and since they saw the writing on the wall, they did. I have to say I worked with the same thing has happened at the Civil Rights Division at ADA or the Department of Justice that it's really been hollowed out. In fact, many people would say the Civil Rights Division, for all intents and purposes, doesn't exist anymore. So, and I worked with five attorneys, young, bright attorneys on discrimination cases against students with disabilities. They all left because they knew they'd get fired. So they took the severance and left, sometimes without jobs. But
Right.
so there's
So
really no lower echelon. And what is happening, I mean, as you know, in 504 complaints, I think last year, what did they have, 15,000 or maybe more than that? And they were
right.
behind this year. And now with half the workforce, they're really going to be behind.
Yeah, so I get subscribed to Special Education Action. Do you know what they are? So they
I've
put
heard of
out
them.
two emails recently that the Office for Civil Rights doubles publication of disability discrimination cases, that they're actually turning them quicker. So
Mhm.
I mean, have you seen that?
No, in fact, there was an article, I can't remember, from an agency in Texas. I have the URL right here where they said basically the opposite. They were
Yeah.
saying parents are really without any recourse now because the state complaints tend to be very, state by state. Some states do a good job, some
Yeah.
states do nothing.
Right.
Um, but the 504 thing is gone unless the 504 through Office for Civil Rights. I mean, you can still sue,
Right.
and that goes a different route.
Right.
That goes through the courts,
Yeah.
federal courts.
Yeah. I don't know. I just so I've seen 2 or 3 emails from them about that. So I mean, I still have a case from 2000 October of 2021 that's still, not settled. So I guess that'll just continue to be, parcel itself out.
Yeah.
Yeah. So do we have any other pending cases that are coming up that are getting a lot of traction that you know of?
Yeah, actually, that case, I think it's going to be important, but the importance of that case is it's really combines with the Perez v. Sturgis. And I think the two decisions together are very much favorable to parents
Yeah.
and advocates because now monetary damages are available. Of course, monetary damages, the whole idea of monetary damages is punishment for inappropriate actions. And that's available under Perez v. Sturgis. And so that's likely to be used by advocate attorneys more frequently, I think.
Awesome.
There
So,
is another interesting case that could be appealed to the Supreme Court. I'm really not certain if it has been or if there's intent to, but it's a case called William A.
mhm.
out of the Sixth Circuit Court of Appeals. And the actual was William A. v. Clarksville, Montgomery County School District. That was also in 2025. And in this case, I would say probably in this case, um, I would think parents are going to be suing for monetary damages. It was a, it was a pretty bad case, I think. The parents in this case, William A's parents, alleged that the school district had failed to teach their son to read, and because they had not offered him a FAPE as required by the idea, and he had basically gone through high school, and when he got into high school, his special ed teacher said, "This child can't read," and in the ruling, the Sixth Circuit Court of Appeals, so again, a very important court, said IDEA does not guarantee any particular outcome, but it does guarantee that a student's IEP teams are going to develop and implement special ed programs that help students overcome the particular obstacles caused by their disability. And when IEP teams fail to do this and IEPs don't accomplish the same, they may violate a student's right to receive a FAPE. And the problem was in this case is the high school did a lot of accommodations in terms of reading because he couldn't read. They used text readers
Ugh,
to allow him to read. And because he couldn't write, they used AI
ugh,
to allow him to write.
yeah.
And essentially, the court said, that's not teaching.
Mm-mm.
You denied a FAPE because,
That is something I yell from the mountaintops. I was in a meeting today. We just read to everybody. It literally says, I was in an IEP meeting for a little kid today, and they had checked oral admin, math, reading, science. I mean, he didn't even have all of his permanent teeth. And so what
yeah,
happens is nobody's going to read to you when you're 25. So you're not
no,
teaching a skill, you're just
yeah.
handicapping the child more. So it's
And
really
that's,
important for advocates to really look through the paperwork because that is recusing the school from teaching and inhibiting the student from learning.
yeah. And that's essentially what the circuit court said is you're making all these accommodations and you're masking the child's disability. You're not doing anything about the fact that he cannot read.
That's good.
So
When,
I mean that will be a very important case, I think.
and what state is that out of?
That one is out of let's see, I'm trying to think of Montgomery School, Tennessee, I believe.
Tennessee.
I believe
Okay.
it's Tennessee, yeah. I could give you the URL of the case if you'd like and put it
Yeah,
in the chat here.
yeah,
Uh,
that'd be great.
yeah, and that one I could see as possibly being appealed because I think the parents are going to have a really kind of a good case for monetary damages. So they may, they'd have to sue separately, but it could be that they would sue not under the idea, but for discrimination or for monetary damages under 504, I would think.
When we've had a couple of trips this spring and summer to Washington, D.C., meeting with countless lawmakers and decision makers and their staff. And what we heard, obviously, it's not done yet or it hasn't been done. Have you heard that there's a probability that IDEA will go over to DOJ?
Part of it, they were, I think the enforcement wing, the idea, the notion was that the enforcement wing would, by the way, I just put the in the
Oh,
chat.
oh, thank you.
That's where you can find the case.
Okay.
The enforcement wing might go to Department of Justice. The problem is they're not. I don't know if they're really prepared because of what's happened in the Civil Rights Division, which would be the division that enforces, would be 504 as well as the
Right.
ADA, and they're like about maybe even 60% right now. My understanding is the rest of it Part B could go to HHS, but
Okay.
there's nothing on nothing I mean, it's just been talk. There's
Right.
really been nothing. And actually, uh, legislators and the executive branch, I think they don't really want to mess that much with special ed. I mean, as you know, it's been very bipartisan over the years. And the advocacy community is very strong
Yeah.
and makes their voice heard. So
Yeah.
I think I mean, right now, in terms of what's happening in the Department of Education, probably special education has been hit a little less hard than the rest. I think there tends to be there's a tendency to, I think, to avoid what may be pitched as hurting students with disabilities.
Yeah. Okay.
And I
We
don't,
have
by the way,
questions.
we were talking about reauthorization too. I don't see that on the horizon at all. I mean, there's some that would like it, but I think the big agencies really are not for reauthorization at this point.
Yeah. Okay. All right, the great Stephanie. So anybody that has questions, if you want to just put them in the chat or wherever, Stephanie's going to read those. Because we can see your questions, we can't see you or hear you, but we certainly want to address them. So do we have questions, Stephanie?
We have two. One is monetary damages. I think you guys already addressed this. So monetary damages such as attorney fees or monetary damages, does that
Well,
more so or less, what does that include for this case and what advocates and parents need to be aware of?
Well, first off, attorney's fees, they've been possible. Parents have been able to collect attorney's fees since 1986. The Handicapped Children's Protection Act, which just became an amendment and was folded into the idea, allowed the attorney's fees or included attorney's fees, which said if parents prevail on one or more major issues they raise, they may collect attorney's fees. So that's always been there. The new thing is, of course, monetary damages, because the courts had pretty much slammed the door shut on getting monetary damages through the idea. But right now, of course, what they're saying, what they said, what the court said in Perez v. Sturgis, is that since there are no monetary damages under the idea, and every court has pretty much held that, you don't have, if you sue for monetary damages, you don't have to go under the idea and exhaust administrative remedies. You could just move straight to, discrimination or under 504 and sue for monetary damages. That's the new thing.
Thank you for that. So we have one more, and this was more towards the discussion about advocates looking at the paperwork and accommodations and the conversation that you all were having. What specifically do parents and advocates need to be looking at in possibly alleviating or relieving the school from their responsibility to educate kiddos?
So, I
Did
mean,
you?
I'll address that first, and then Dr. Yell can. I think that we have, the blessing of this thing, technology, which is called a device, and that's what it really can be, divisive, right? I'm all for anything that mitigates the acuity of a disability, but we have children in life skills all the way up to, chemistry 3, and we're just shoving them in front of a computer. And I don't care how good your software is, it's not specially designed instruction. And it doesn't teach you, our job in special ed is to teach a skill, right? Or a strategy to help you self-manage your disability. But if Mitch works at Home Depot, he's not going to, be asking his computer to read him what is this order that he's supposed to be packing, right? So it sounds good, right? But it's not teaching them to read. We need to teach them to read.
That's essentially, of course, what the Sixth Circuit said in William A. is that they weren't teaching him to read, and that was his primary disability, a learning disability, and could not read. And I think he was from literally first grade all the way through high school. They just didn't teach him to read. They used these accommodations to mask, as the court said, mask his disability, but they never did teach him. So it wasn't specially designed instruction.
Yeah. So Mitch, when you say that we can sue through 504, what does that look like? Do I have to go find a federal attorney in a big city? What does that look like?
Well, yeah, basically that's not let's see if I can find it here. There's essentially, the different ways we have in terms of so OCR, monetary damages through 504 are discrimination, and you have to file a lawsuit. And of course, that means the parent needs a lawyer, the school will get a lawyer, and if it's not settled, and by the way, most cases are settled, um, it could go to trial, which becomes more expensive.
Right. But those are federal attorneys, I assume.
I would say your best bet is attorneys who understand discrimination. Federal attorneys would be your best bet to do that.
Okay.
People who have practiced in that realm.
Okay. Awesome. Stephanie, do we have other questions?
The discussion you guys just had actually addressed the last question that had been submitted.
Yeah, I can, as we're talking about this, I can hear Stephanie's ears burning, and that's a conversation for another day. But
you are so right.
yeah. So and when somebody said, what are we looking for in the paperwork? One of the things I train on is I'm not trying to penalize teachers. I'm not trying to give them 52 goals, but the goal addresses a found deficit in the present level, right? And it's going to have a corresponding service and almost always a goal. But the accommodations, I think for years, maybe Mitch will agree with me, really, sometimes I'll see like so many accommodations. And what we should have given him was special ed services instead of all these accommodations. And the truth is, a teacher's not implementing 10, 15, 20 accommodations before she says good morning. Right. And I think if you really stop and like most people just kind of gloss over the accommodations, if you look at how weighty the accommodations are, I always say they layer on each other. And for me, a lot of times that is special ed, right? And unrealistic for the general ed teacher to deliver. So really, I think we get really excited about goals. We get really excited about the dessert page, right? Special ed services, but look at those accommodations and think about who's going to implement them. What time does it take? And does it bode better to give him a special ed service and a goal than all of these accommodations?
I agree 100%. I think one of the problems is and I'm sure you've seen this too, is there's so many accommodations that put in a student's IEP. You just know they're not going to be implemented.
Yeah.
And it's even more difficult at the high school level. And one of the things that I always blanch when I see is people getting or going to an in-service and getting a cookbook of accommodations. If they have this
I
disability
know.
here in
This is an ADHD accommodation. This
yeah.
is for autism. I always go, there's no such thing.
No, there's not. And accommodations should be individualized, just like an IE, just like specially designed instruction. They should be something that allows the child to, actually uh, be successful in their education, in the general ed curriculum, and not just, one attorney from Texas, I know you know of, David Richards,
Yep.
often talks about the all-you-can-eat smorgasbord of accommodations. Is they just here's a good one, here's a good one, here's a good one, there's a good one up there. Let's put them all in the
And I
IEP.
think really well-meaning teachers open these, I don't know who made software. Mitch, you and I should have a
Yeah.
summer session. We make our own software, but they put 8,000 and you're like, he could need that. He might need that. I always say it's like, how many silver hoops do I have? A million. And so the
Yeah.
accommodation, we know without the accommodation, he will not make progress on his IEPs, or without the accommodation, we can't implement the 504. And it either is required or it needs to go away. And I think we just have to take time, right? We have to reasonably calculate this and take time to look at it. And most of the times an IEP needs to be pruned. And that would even make it more individualized most of the time.
Yeah, absolutely. And that's an issue. One of the most common reasons for 504 complaints is failure to implement.
Yes.
And the more accommodations, the more likely you're going to get a failure to implement.
Yeah. People always go, well, it doesn't say in the law we have to take data. And always, the law is assumptive, right? It assumes that you know what it means.
Yeah.
How I know that it is the law is because when you have a federal complaint or you have a state complaint, the first thing they ask for is for you to send your written data, right? So progress monitoring and measuring, that's all we do in school. We teach and measure, we teach and measure. So I don't know why we don't think we don't have to teach and measure in special ed. So but I think we just keep working on this. I think that these are really so happy for these families. I think that even sometimes in IEP goals, we put requirements on special ed kids in a goal that we don't even ask for non-disabled, that he needs to advocate, he needs to self-advocate, he needs to self-regulate, he needs to have a checklist. I'm like, we're not, I mean, sometimes we make the responsibility of a student with a disability even weightier than a non-disabled student. So I think
Yeah.
this is a great decision. It makes me very, very happy that the courts have valid cases to rule on.
Mhm.
I've always thought that this right to due process and our procedural rights are, they're weighty, right? And so I feel like anytime that we can get equity in that area, it's good. So Stephanie, do you have any
Yeah.
more questions, or do you have a question? Or go ahead, Mitch.
Okay, well, what I was going to say is in the chat, I put the SCOTUS blog connection. There is an independent agency called, well, they maintain a website partially through the Cornell Law Institute, I think, called SCOTUS blog, which is a really good website.
Yes.
And they do an amazing job. And what I did is put in the actual A.J.T, the Osseo case. Really good job. They do all of the amicus briefs. They have the Solicitor General of the United States always submits a brief, and that's a really important one to look at because people call the Solicitor General the 10th member of the Supreme Court.
Wow.
Essentially, they tell the court, well, here's what the position of the federal government is regarding this case. And the court really takes that very seriously. They really read the amicus briefs. So very interesting. And you can get all the decisions too. And also they write a really good summary, and they have a real nice summary of the A.J.T case.
Oh, good,
Yeah.
good. Have we had, I know we usually get one, but do you think that we'll soon be receiving an OSEP Q&A about the Osseo case?
Possibly, the folks that write that tend to write that are in some cases not there anymore, and they're kind of scrambling to place people. But one thing people may want to look at is Perez usually keeps up with those. Perez Perry Zirkel ZIRKEL.com has an article on his initial impressions of the A.J.T case, and it goes over a lot of the things we went over today. He tends to kind of sort of be a little on the school district side, so you have to look at it a little bit with a little bit jaundiced eye, I guess. But he's very good too.
He's very good.
Yeah.
Yeah. So you have another book coming out. We all own your book, but the 75th edition, I think you're like battling out with iPhones. What edition are you on now?
It's well, as if I had made as much money as Jobs made on the iPhone, that would have been good, but I
Yeah.
didn't. But I was able to buy a couple nice lunches. No, actually, it's not quite the 76th edition. It was the 6th edition of my
Okay.
textbook, The Law and Special Ed. And I finished it up, and I'm just doing PowerPoint for teachers and things like that. But it's supposed to be out for fall.
Oh, good,
So,
good. Everybody, it's one of our best sellers on our link tree. They're like, "Where'd you get that?" I'm like, "The interweb." So, yeah, we always appreciate all of. And if you don't, if you don't have any of Mitchell Yell's resources, all of them you should listen to, record. He is brilliant and genius, but he says it in ways that are usable for parents, educators, and advocates. So avail yourself of any of his publications. He's the best of the best. So any other questions we have, Stephanie, or?
We don't, but I'm very excited to be able to hold up one of his new books when I'm training school board members.
Yeah. And what is his new book you're going to hold up?
It's going to be the 6th edition.
The 6th edition.
Ah, oh,
Yeah.
they put a brand
Yes.
spanking new cover on it too.
Oh, they did?
Yes, they did.
Okay. Canny has a question. Canny, you want to type that in the chat and then Stephanie can read that?
And while you're typing that, I could put another, oh yeah, perryzirkel.com. Thanks for putting that in, Stephanie. This is another kind of interesting article that you might, it's actually out of, what is the name? I don't even, it's online only, and it's the 74, it's called. It's out of Texas. And they did a piece, called "For Decades, the Feds Were the Last Best Hope for Special Ed Kids. What Happens Now?" And it's about state complaints with school districts.
Oh, I want to get that. So Stephanie, I know that so all of you young people, including Mitchell Yell, know how to use the chat. I feel like if I learned how to use the chat, I would probably be on the Supreme Court justices. But I'm sure it's not as complicated as I think it is. I mean, I did use an 8-track tape player.
Well, then you can do this.
Yeah, so we'll send that out with the recording. Stephanie, did Canny, was she able to type her question?
I don't know if it was Kenny. It came through as anonymous, but we have someone who was recently told by the Department of Rehabilitation that a high school student needs to advocate for themselves because they're going to have to do that on the job.
Well, after they're 18 years of age, they have to, all rights, depending on your state, usually go to the child. But when children when students lose the protections of IDEA, either when they graduate with a legitimate diploma or age 21, say they go to a technical school or a college, they do have to advocate for themselves. In fact, we're used to things like child find in schools where they will go looking for kids with disabilities. That's not going to happen in a post-secondary school. They have to go to disabled student services and say, "I have a disability," and advocate for themselves. So that's probably what they mean by that, I would guess. I think the notion that children should be taught from a young age to advocate for themselves is a good idea, but at some point, of course, they have to begin advocating for themselves.
Yeah, thank you for that. I even have one of my kiddos that came home and saw a need for a schedule change. It was my high schooler, and he had gone and talked to the principal and started that conversation. So it's good to see as we equip them with those skills that they are able to start practicing them in a safe environment, in a manner where there is additional guidance and coaching that's available. We have two additional questions. What is the new burden of evidence since it has moved to a lower standard for A.J.T versus Osseo?
Well, that's kind of interesting. The court didn't really say. Now, Justice Jackson and Kagan and Sotomayor wrote a concurrence agreeing with the decision, but saying the court should say intent was not an issue. If they discriminate, they discriminate. That was really not signed on to by anybody else. And as I said, Justices Kavanaugh and Thomas, of course, actually said that if a proper case comes, they may hold that a child has no right to, under the Constitution, to an education, and they could have a higher standard. So that's troublesome. Gorsuch, Barrett, Coney Brown, and Roberts didn't sign on, which is encouraging, which means they are probably more in agreement with the idea of no bad faith, no gross misjudgment, but they're not necessarily going to as far as Jackson and Kagan and Sotomayor and saying it's an issue of they should not have to not have to prove intent at all, that they should just be able to show discrimination. So there really is no standard. It's just not bad faith and gross misjudgment.
Well, that's a relief. Yeah.
Exactly. Yes, that is absolutely a relief.
Yeah.
The last question that we had come through was if a school district is interested in receiving training directly from you, Karen, how do they go about that?
Oh, you just reach, I mean, if there's anything we can do to support y'all, just reach out to advocate at specialeducationacademy.com. And I'm a pretty good trainer, but Dr. Yell is one of the most amazing trainers for school districts, and he will tell us what you would think it's so tiny, I would have it memorized, but Mitch, you want to tell us your email?
Just MYELL at SC for South Carolina.edu.
Yeah.
So
Dr. Yell,
yell at SC.
Dr. Yell's amazing. So we both love training anybody that's interested in serving kids at the highest level.
Mm-hmm. Now, I did want to say something about, I did put in that link to the 74 article, and it's a good article. I think there's a few errors in it, though, and Cadre, the Center for Appropriate Dispute Resolution, has pointed those out, that there are some errors in the article. But
like
I think
clerical errors or like
well, kind of like they would say things like, well, parents have to sign a non-disclosure agreement. They don't have to do that. So there were errors, but actually they've gone and corrected most of them themselves. So if you looked at that article, they say amendment such and such date.
You know, if we ever do get IDA amended, reauthorized, could we take out the phrase that school districts are even allowed to say we have to? That would make so many of my meetings so much more pleasant.
Yeah,
We have
probably.
to. Yeah. So thank you for coming. You're always a blessing and a benefit to all of us. Stephanie, do we have anything else?
We have answered all the questions in the chat for this evening.
Awesome. Do you have anything else, Mitch?
Well, the only thing I did have is the William A. case that I talked about. I think that's a important case. Right now, it was heard by the U.S. Court of Appeals for the Sixth Circuit. Now, the U.S. Courts of Appeals are right under the Supreme Court. The Sixth Circuit states now that it only really doesn't apply to technically to any but states in the Sixth Circuit, which are Kentucky, Michigan, Ohio, Tennessee.
See,
But I think it's going to be a very, what we call, and the lawyers would call, a very persuasive decision. And I think that's a very strong decision. You know, the accommodations don't equal SDI. That is a very good decision. And I think that could possibly be appealed because, you know, to the Supreme Court. But I kind of see a possibility of parents suing for monetary damages in this case. But it may very well go to the Supreme Court over the issue of, you know, accommodations not necessarily providing faith, but masking
right,
disabilities. So
right.
that's a big case to watch.
Yeah, I think it's good. We're talking about, you know, education. It feels like for the first time in my life, and I'm 100 years old, that we're actually talking about education, good, bad, and ugly. I mean, I don't remember in the past 60 years of talking about education. I might have missed it, but you know, I'm happy that it's getting attention, and I'm so happy that parents are getting some gains. They're long overdue.
Hmm. You know, another interesting thing, maybe this is something I know you've talked about before, and we've talked about actually, is 504 complaints are on the rise. You know,
Yeah,
there's going to be less, there may be less means to work on them, but they're on the rise. And actually, the number of 504 students in schools is also on the rise.
yeah,
504 only students, I would say, that
yeah.
are not, of course, IDEA students are doubly covered because they're also covered under 504. But there are a lot of students that are 504 only. Those
Yeah.
kids with disabilities who are not covered under IDEA, but are covered under 504 and ADA.
Yeah, absolutely. We've been getting for myself and my partners, and of course I train everybody on state complaints. We've really kind of locked it in. We've really gotten it really good. I wish there was a different mechanism. I was able to speak with one of our representatives, we'll just say that, and I said, I'll get 10 complaints against one district for the same thing and nothing changes. And he said, respectfully, most states encourage school districts to not violate the law.
Yeah,
Oh, we need to have a different word than encourage, right?
yeah,
Like,
you would hope so.
can you imagine if you got speeding tickets every day and the police officer said, I'd like to encourage you to drive slower? I really we're working with an amazing representative that we're really going to work on an enforcement mechanism. We just passed a bill. I'm going to get it backwards, Stephanie. It's either 586 or 568 out of the House. And it actually has layers of sanctions and enforcement mechanisms if you don't deliver
Oh,
PT, OT. Stephanie can help me get that to you. And I was like, this is the first time ever, you know?
oh,
And as a business owner, if I don't do something right, everywhere else in the world, if we don't do something right, there's a consequence, usually monetary, that we feel, but don't do that again for 50 years. I'm like, we got to pick up the pace.
yeah, I would love to see that, Stephanie,
Yeah.
if you would email it to me. That'd be great. Well, as a hearing officer in South Carolina, you know, I see some districts are repeat offenders over and
Yeah.
over. They do the same thing.
Yeah.
Um,
Yeah. Yeah. And
so
so, if there was, a way, and we're working, we're eating this elephant one bite at a time, but like literally the next day we're doing the same thing. Have a lovely school district that just all of my complaints are found substantiated. And I said to her, part of the requirement was, I feel like we're getting back in the meeting. I said, so part of the requirement was, of course, part of our ask is always that there's training. I feel like if we train some people that we could probably eliminate most of this. And she said, we did that. I said, so who was trained? And I'm thinking she's going to say the teacher, special educator, the principal. I would be mistaken. And she rattled off 4 names. I said, who are those people? They work at the district level.
oh,
And I
really?
screamed inside of my head, like, we got to fix this bingo ball. It's like,
Yeah.
they don't even work with children. So it's just an obligatory check mark, so we got to
Yeah.
fix that.
Well, and I think too, as you know, we've talked about this before, is principals often have no clue. Um, And that's a real problem. That's what I'm doing mostly now is training principals because they really need to. I mean, if there's anybody, the head of the LEA for a school district,
You're the rep. Yeah.
yeah,
Yeah.
yeah, and it's like an animal farm where they said, the pig said, you know, all the animals are equal. The pigs are just a little more equal. And same way with the LEA rep.
Yeah.
Everybody in the IEP team is equal, but the parents and the LEA rep are more equal. Unfortunately, a lot of times the LEA rep is not well versed in special education or discrimination for that matter.
Yeah. Or I'll say, Mr. Principal or Miss Principal or Miss Counselor, you're the LEA rep. Or what is your position on this? Well, you know what, Karen? I'm going to lean on my professionals.
Yeah,
Oh, then why are you the leader? Right.
yeah,
And
right.
it's half the time I'm like, do you want to get off your phone? I mean, they're ready to read the assurances. Okay, I'd like to read the assurance. I was in
Yeah.
a meeting the other day, and I'm sure you would appreciate this. I said, so the parents have been denied their assurances. And she's like, you can't say that. Oh, actually, I can't. She's like, I don't think you can say that. Oh, okay, I can say that. Because none of that happened, even though you're saying it happened. And she was like, I've never heard of this before. This lady was like, we were not expecting you to say this. I'm like, that's what my first husband said.
That's too bad. Well, it's our state doesn't even require that principals have training in special ed. I mean, in special ed law, I mean, they have to
Is there any
take.
state that requires it, Mitch?
Not that I know of. Not that I
No.
know of. And a lot of states, like South Carolina being one, take their special ed directors or principals and don't even have to have a special ed degree. Just so long as they have their principal certification, which oftentimes means no special ed or very little special ed knowledge.
Yeah, in Texas, to be the executive director of special ed for a district, and our districts in Texas, as you can imagine, are huge. It
Yeah.
literally says in the statute, some knowledge, special ed. Like, can you like,
Yeah.
wow, like okay, shouldn't.
So what that means in most states, I think, is just an introductory course where they just cover some disabilities, a little bit of law, but not much. None of them, I'm not aware of any states that require special ed law
Yeah,
courses for principals. They require they usually require educational law, and that means in one semester you get maybe a week, 2 weeks of special ed. The
yeah,
rest of it is school dress codes and things like that.
yeah. Yep. Not smoking in the bathroom.
Yeah.
So we did just pass a really good law in Texas. No communication devices in Texas. And in Texas, we have 5.5 million children. And of course, all my clients called, Karen, we need to go in there, have an IEP meeting, put the phones back. I'm like, no, 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 no. I'm so excited about teachers being able to teach and children talking to each other. So, and it even has, so it says prohibition. I love that. So no phones during the school day, while on campus. I think that's fantastic because most teachers now are not by nature good managers of, especially sassy middle schoolers. And they'll be like,
Mhm.
can you put your phone away, Mitch? No. All right. Like that. And so I think this really is going to be a great thing. Obviously, if you would need a Dexcom or you need it for, medical reasons or it's part of your IEP, that's different. But parents were just having a fit. I said, I went to school where we had party lines in my house. So
Yeah, me
it'll
too.
it'll be fine. It'll be fine. So I'm excited about that.
Yeah, I had the opportunity in our district where I sit on the board to walk our campuses, all 15 of them, on the first day of school, and to see kiddos engaging with one another. Phones were not out, from the elementary campuses all the way to the high school campuses, and the compliance. I mean, I recall being in high school, when phones first came out or dress codes were a big deal, and the compliance piece was the hardest part. Here, with the legislative body behind schools, it's a no, this isn't even us. This isn't our school board.
Yeah,
The
it's a state
answer is
law.
no. And kiddos were not pushing back or anything. Phones were in bags. I actually didn't see any phones until one of the very last campuses towards the end of the day when we were walking that particular campus. It was about 2:45 and they were getting ready for dismissal, exactly when this legislator said that they could have their phones back. So it was great. I can tell parents, hey, kiddos are having fun and things are going well in the schoolhouse, even though the phones aren't there.
Yeah. Good stuff.
And I can see the chat for a brief second, they go away, but I see Alan had brought up a couple points. One of them was that Alan Durder said that there is a special ed law course required of principals.
There is?
That's what he
Does
said.
it happen in like when they're like 21 years old, or is it annual? And I think that college is great, I've been told. But I mean, you need to, I mean, we have every year in Texas 40 new pages of administrative code solely for special ed. So the fact that you don't need, if you change oil for a living, you have to have continuing ed every 2 years on that. So
Yeah.
you know, we gotta, that's one of the other bills that we're working with for a rep, that there is a measure of special ed continuing ed, even if it was 2 hours every 2 years, something, right? Can you spell FAPE?
Yeah. But you know, IDEA actually used to, back in the old days, when it was the Education for All Handicapped Children Act, had the comprehensive system of personnel development. They dropped that, and
yeah,
there's no such
well, we're
requirement now.
we're bringing it back. So if we can get the phone thing, we are going the right direction. Well, thank you, Mitch. You're always a joy to have, and we'll have you on again. If you guys have any questions, Mitch's email is in there. Always, you can reach out to us at advocate@specialeducationacademy.com. Remember, we get it right for the child, we get it right for everybody. We'll see you guys in the next training.
Thank you. Bye-bye.